I'd like us to take a look at the Uniform Commercial Code. This is in our textbook under sales of goods, but it's a fairly broad chapter, and it's an attempt, as we'll see, um, by primarily instigated by scholars, from what I can understand, by legal scholars, um, but an attempt to try to get a relatively uniform system of state law transactions because the state courts tend to rule contracts. And so we might have varieties of contractual agreements um, that would kind of gum up the works of commerce, if you will. Anyway, what they came up with was a uniform commercial code. There's been an attempt, and I apologize, I'm blanking on. I think this came around 1972, and they rewrote it around 2004. But the last time I checked, nobody had adopted the modified version. Now maybe that's in the works, and my research is a little late. But I think that what we have is that there's an existing law kind of status quo preference, that this is something we get in the States. Why mess with something that really works pretty well? They may have cleaned up some little areas of it that we'll be talking about, but one state that is a pretty big standout is Louisiana. It's more of a Napoleonic code state. However, I think a lot of companies work around that by going, putting in their standing agreements. We're going to govern this by the UCC, unless they've got a long course of dealing together that makes them look the same. I've got a link here that I haven't been to in a while, so bear with me. I'm going to click out on it and see what it goes to. Um, and this just tells us what the articles are of the UCC. I think that's important that we know this. Article 1, general provisions, Article 2, and then Article 2A. Article 2 is what we're going to be talking about. That's the sale of goods, all right? Article 3 is negotiable instruments. This is mortgages, things like that. Those can quickly be sold, your student loan. There's one on bank deposits, fund transfers, letters of credit, bulk transfers, and there's a link to all of this. So uniformcommercialcode.uslegal.com will kind of get you there. Secured transactions, which we'll talk about a little bit, but we talk about it more in bankruptcy. And that's basically we take a security interest, usually in a good, like a combine or cars or a fleet of cars or whatever, and that gives us priority in bankruptcy. So there's a whole bunch of rules here. I know a few lawyers who work in the UCC. They actually tend to be in just one article. It's just sort of a narrow field of operation, and they stay there all the time. So anyway, that kind of lets us go there. One of the advantages of the UCC is that it was drafted by scholars in conjunction with leaders of states. Some states have taken bits and pieces of it, like some of them haven't taken all the banking stuff in. They already had their own banking rules and they didn't want to play with it. I can't give you specifics on each and every one of those. It's just kind of a general comment that I think you may need to look at. And I think you've always got a right in the states for legislative independence, which a lot of people want. I really love that green color. Is a garage sale covered under the UCC? Potentially, but probably not. All right. So we're just going to focus on Article 2, sales, and we're really talking about sales of goods. Okay. This hand mirror is generally a good, but this faucet attached in your if it's attached in your home, is what we might call a fixture. And that is, it's going to tend to go with the home. Now, oddly, things like the stove and the dishwasher, things that are installed and a little hard to get out, they're not that hard to get out, so they actually can go with the homeowner. That's why a lot of times you've got to sit there carefully when you're buying a home and go, what stays? The furnace stays, the hot water heater may not, because a hot water heater is immovable. It's real easy to get to. So I've given you two definitions on the slide: movables or not real estate. Is that really the way we ought to be going? I'm not sure, but if you're looking at this and you're not sure if it's a good, the thing you ought to do is maybe there's another article of the UCC, such as what I just walked you through, that might cover what you're talking about. But we're really talking here about ordinary goods. So everything you can go down to the Office Depot or Home Depot or Lowe's or wherever and Target and get it. Almost everything there is a good. One of the things we're going to see, though, is that if only in cases where we have a sale that's of a value greater than $500, do we even need a writing? Now, sometimes the state stuff comes over this. Certainly transfers of cars in the state of Missouri, you need a bill of sale. I don't believe we needed one across the river when I was a kid in Illinois. That may have changed. In order to register the car, all you needed was possession. You could get it. But here we are. We're looking for a written contract. Again, we're flying back into what we talked about, the statute of frauds. We don't want people to be able to testify that, hey, I bought that, he needs to give it to me. Ordinarily something of $500 value or greater, we're going to write out a note. At least that's the thinking in the law. You're used to, in contracts, the mirror image rule. You have to have exactly the same acceptance as you had offer. Not so much in the UCC. Now, my not is probably a little bit overexpressive, but it really looks at, is that a material component of the transaction? One example is, say it's delivery next Tuesday, contract entered into on Friday, they bring it actually 2 Tuesdays later. You're probably still stuck, even though they're a week late, because you weren't specific enough. Next Tuesday could, on a Friday deal, because of transmission of order and everything else, maybe mean not till the Tuesday after this one. It's not perfectly clear. But, unless we make it clear that time is of the essence in delivery, it may be that they've actually complied. They've substantially conformed. And maybe this will make a little more sense as we talk about cure. I wanted to say maintenance and cure, but that's another part of the law that's related to admiralty and injuries of individuals. But we don't have to have a perfect mirror image. They may specify, we want delivered to our dock, as we'll talk in the next ones. Let's jump to it maybe. Let's go to some key elements, and I don't know if you could hear that little tiny click. I think we'll get to that in a second, but it's not quite as rigid. It is not just perfect. The purpose of the UCC is to keep commerce flowing. We can solve the problem later. Get the goods there. Get the goods there. If there's a quibble over the ultimate price, we can quibble about it, but let's move it. Because that person needs it. Boy, I say a lot. That person needs it right now so they can sell it in their store tomorrow. One of the things that I find a little shocking is something called the perfect tender rule. If I walk up and agree that I will deliver 1,000 shirts, if there's a flaw in one of them, they can send it all back. And it took me a while to get my head around this, but I think if you look at it the way we might inspect 1,000 shirts, we're not necessarily going to pull out 1,000. We're probably going to pull out 40. And if we find a defect in one of those 40, well, the numbers aren't real good, frankly. And so this is part of why we sometimes see merchants sending extras so that they can basically say, here's my cure. I gave you some extras. I won't charge you for them, or if you sell them, we'll work a side deal or whatever. But, because there is a chance I've got a button missing on a shirt, or the threads are loose, or something like that. So what we have in the perfect tender rule is we can say, we opened this up, we did a random inspection, we found 3 defects on the 50 products we looked at. We're sending this all back to you. We want a perfect tender. The seller has the right. You're the buyer, and I haven't used that. There's a buyer and a seller in the UCC, and you have to be careful as you're reading all the code in there that you know whether you're the buyer or you're the seller. But that's that Article 1 definitions, gives you a pretty good idea of that. The seller has the right to cure in a reasonable fashion, in a reasonably commercially reasonable amount of time. We can't say have them here in an hour if we are saying these are defective. If we've already given them, say, 5 days to get them there, we may have to do it 5 days later. At the same time, that seller has the duty to immediately say, we cannot provide that, or we can't do that, or we won't do that, or here, we'll send you another 100. Will that, based on the ratio you're telling us, will that be okay? Will that cover you? And then it's up to them to say yes or no. If they can't get it fixed, we as the buyer have the right to cover. That is, go to a different entity, and then the original seller owes all our additional costs. So if the price is higher, or the delivery terms are different, or anything like that, it's going to be on the seller to pay all that. But our purpose here is let's move things in a commercially reasonable period of time. One of the interesting things in this is that oftentimes price, delivery, and time can all be left open. I'm going to buy 1,000 shirts from you, period. I send them a note, that basically says, you agree that you will sell me 1,000 shirts. That's basically all I need. I've got to specify I need so many smalls, so many mediums, blah, blah, blah. But I don't need much. We go back to that statute of frauds. It doesn't need a lot of detail in terms of the writing. It just sort of needs to give us an idea that these two have come to an agreement over what's happening. Place of delivery, how it's delivered, can be left open, and the timing of it can even be left open. That's a little hard to think of when we're thinking about, I've got to have it by a certain day, but it's because it's because the purpose of this part of the code is to give you is to keep the goods flowing, keep commerce going. We can solve it afterwards, get the goods there, make them of a commercially reasonable quality, everything else will happen. One of the things we see a lot of in the UCC is battle of the forms. I, as buyer, send you my form. You, as seller, send me your form. They may or may not disagree on terms, okay? Even though we both send our forms and they cross in the mail, unless there's really a material alteration of the core terms of the agreement, 1,000 shirts, 400 are women's shirts, 600 are men's shirts, We will have XYZ, blah, 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 spacing or whatever it is. As long as both basically bear that in mind, but maybe vary as to delivery or time. Now, here's where price, if price is specified in one, that's binding. And if that's altered, well, that's a material alteration, and we may or may not have an agreement. But if it's in a range where we might be able to mediate or modify that, we'll let that go. One of the things that I studied a lot in law school, but never saw much out in real practice, but we spent a lot of time on it in law school, and we spent a lot of time on it in these courses. So it leads me to believe, even though I didn't see much of it, there is a big deal going on here. And I think what really is important is a sort of uniform treatment of warranties. One of the things I think you will see if you look at warranties that you get in almost any good you buy, computer or otherwise, the language is almost identical. In fact, I checked the last 10 I checked, it was identical. I couldn't tell any difference, and it's all because of the law in these three sections of the code. First of all, 2313 is express warranty. Anything that is warranted needs to be in writing. Now we're going to see there's a modification of this. There are a couple of verbal ones that can come out, but you're best off getting that in writing, getting it into the document itself. And express means, so it's something like if someone's selling me a Mercedes and tells me this is the best car in its class, they haven't warranted that it's a perfect car. They've just given their opinion that it is. But if they say that we warrant that this will have no breakdowns for 2 years, and if it does, we will do all the repairs, we get to enforce that. So we get some warranty battles as we see in the car dealership. The one I spent the most time on was 2-314 merchantability. And this is language that it will pass without question in that field or that trade. And so to be merchantable, every good is warranted to be merchantable. So, for instance, this shirt I'm wearing, which is really old, it's 15 or 20 years old, if I had received it from Land's End and the cuffs came off within 3 wearings, they've breached the warranty of merchantability. That would not be a good that conforms within the usual parameters of mercantile goods. It will pass without exception in the trade. That would not. The fact that this shirt has held up somewhat well, except for a frayed collar and one missing button, that is a good merchantable shirt. It's a good, solid, high quality product. And I think this could be, or I always thought coming out of law school, the warranty of merchantability would be how we would do products liability claims, but I never saw that used. I still haven't seen it much. The tort lawyers vastly prefer the products liability super negligence, if you will, that we talk about in another chapter. It looked to me like this gave us all the remedies we want. It was any consequential damages. You build a set of eyeglasses that has a sharp edge and I do damage to myself. To me, that breaches the warranty of merchantability because it shouldn't have a sharp edge. That would not pass without exception in the field. And it seems to me easier to prove, but nobody's using it. Then we get to fitness for a particular purpose. This one can be oral. One of the best examples I know was a couple said, we're going to take this RV and go all over all the mountains in, we're going to go up and down and back and forth across the Rockies. Will this be a good RV for that? And the dealer said, this is a great RV. It's got, and started talking about the real performance of it, particularly its ability to go over 10,000 foot passes and that sort of stuff. Well, it turned out after about 3 months, they couldn't make it up almost any hill. I don't know if they had it overloaded or whatever, but that didn't matter. The fact that they said this thing's great, it's no problem, it works beautifully up to 12,000 feet. They had warranted that for a particular purpose specified by the consumer. And so this is powerful for the consumer. Now, you can probably guess by the content of the slide or the way the slide looks, what the left hand giveth, all these rights under the warranty, the right hand taketh away in 2.3.16 disclaimers. And this is really the language I'm thinking about. The 2.3.16 disclaimers I get on every product are very identical. They're court tested, they work, and so a lot of times they're going to disclaim any and all express warranties, any warranty of a fitness for a particular purpose. They cannot fully disclaim merchantability. That is always in there, but they can do the express and particular purpose. And so you've got to be careful as you're buying to do this. But the particular purpose one, the disclaimers may not work against if the consumer has sufficient indicia of having negotiated for this and only having bought based upon that purpose or based upon that assertion by the seller. This is a consumer protection statute. It is really meant to protect consumers against high knowledge sellers. A lot of what we've talked about before is more sophisticated seller to sophisticated buyer. When we're talking in the consumer realm, a lot of this stuff can go out the window a little bit more. We're going to favor the consumer because the consumer is not dealing with this on a daily basis. When it's merchant to merchant, it's a little bit more, the gloves come off, there are no big holes, so let's not worry too much about it. Particularly between merchants and merchants. Merchants with respect to the good or buyers with respect to the good. Anytime there's going to be a dispute, we want to minimize the chances of this. We're not forced into arbitration, although most of these Battle of the forms will put in arbitration clauses. But one of the things we're going to look at is, where does the dispute lie? Can it be resolved by usage of trade? All right. What we mean about there is, what is kind of the common practice? And that's where we go to the next part, custom and practice. First of all, between these two, do they have a course of dealing between one another that lets us resolve this? And basically the reason that's in there is, look, this is how you've always done it. Why are you griping now? To get people to kind of wake up to the fact that litigation doesn't work very well. Is there a general overarching commercial custom and practice? If not, maybe we look in that field, or even if there is, maybe that field has a different thing. If we're in the oil service supply field, what do most people do under these circumstances? What is the standard in the field? This makes it real simple to resolve, and a lot of times shortcuts litigation because everybody recognizes that's the limit of what we're going to be able to do. I think that's it. It is. And so I hope that helps you. Any questions, call me or email me. Thanks.